Well, Washington State and Oregon State fought the Pac-12, and so far, Washington State and Oregon State have won. That's the update from today. Welcome into the channel. I am John Kurtz. Here on this channel, we talk college football, college basketball, and conference realignment, all from a Big 12 slant. Please consider subscribing if you have not. I'm live Wednesday and Sunday. The live shows are a lot of fun. Take your questions, and I sprinkle in content like this throughout the week. And speaking of the live shows, on the last live show on Sunday, we mentioned the story that Washington State and Oregon State were suing the Pac-12. The crux of the issue here, they argue that the departing members, all the departing members of the conference had not technically been kicked off of the board yet, and George Kliavkoff was trying to schedule a pseudo-board meeting. They feared that those outgoing schools could vote to dissolve the conference, which would keep Oregon State and Washington State from receiving all the assets, including money, that would be due to the conference. That was the crux of the issue, and a judge has ruled in their favor with step one. So I'm going to read to you from articles from Pete Thamel of ESPN and John Wilner of the Pac-12 Hotline on exactly what went down on Monday. So the lead from Pete Thamel's story says this: a state judge in Washington granted a temporary restraining order Monday to prevent the Pac-12 conference from meeting as a board later this week. Judge Gary Leiby ruled in favor of Oregon State and Washington State in Whitman County Superior Court after they jointly filed a complaint Friday that saw the potential of the Pac-12 meeting as a board and voting as an imminent and existential threat to the future of the conference. The ruling for the temporary restraining order prevents a Pac-12 board meeting scheduled for Wednesday and sets up a preliminary injunction hearing that is expected to determine who makes up the voting members of the Pac-12 Board of Directors. So again, the argument from Oregon State and Washington State has been, hey, USC and UCLA, they were not allowed to be on the board anymore. Why are these schools not technically off the board now that they've made their decision to leave as well? So back to the preliminary injunction hearing I mentioned just a second ago in the article. That hearing has not yet been set, but would likely be scheduled in October. It could include document and email discovery from the Pac-12 and member schools and live witness testimony from prominent officials in and around the Pac-12. Now, if that sounds like that could get really interesting, that's because that could get really interesting. We're talking about document and email discovery from the Pac-12. Man, I would love to see some of the emails that have been flying back and forth in the aftermath of all of this. That could be great entertainment for us all. Here's a quote from Drew Tumalo, counsel to Washington State, and school president Kirk Schultz. He says, quote, "Today's ruling is an important first step to bring clarity and fairness to Pac-12 governance. The future of the Pac-12 should be controlled by the schools who stay, not those who go." And that seems pretty simple, right? I mean, I don't care what side of the realignment aisle you've been on. Like, I am very much here to defend Washington State and Oregon State here. You can't have your cake and eat it too if you're the outgoing schools. You can't keep those schools from maintaining the assets. They're sticking around. Go take your ball and go home. Go to your new league and do not screw these guys over any further. Oregon State and Washington State have argued that they should be the only voting members remaining in the conference, citing precedent that previous members who've notified the Pac-12 of their withdrawal from the league have lost voting rights. In the past 18 months, 10 members have departed the Pac-12. That's left only Oregon State and Washington State to sift through the assets and liabilities as they attempt to determine whether it's worth pushing forward with the league. There's value in the league's name, TV network, remaining assets, and NCAA men's basketball tournament units that could be used to lure or help facilitate a merger with the Mountain West. Oregon State and Washington State filed supporting exhibits that included a letter from the Pac-12's general counsel to Colorado in July that informed it explicitly that, effective immediately, Colorado no longer has the right to vote on any matter before the board. So there's another example of previous precedent. In the hearing Monday, attorney Eric McMichael argued on behalf of Oregon State and Washington State that all the schools want is to see if they can save the conference and allow it to move forward. The Pac-12's attorney present at the hearing, Mark Lambert, so the guy defending the Pac-12 is Mark Lambert. He argued for the meeting to be held in order to conduct league business. He said the league has nearly 200 employees and is working to keep its lights on and keep critical employees in place. He added that Commissioner George Kliavkoff, who was not present at the hearing, is in a terrible position and is just trying to keep league business moving smoothly. Poor Georgie, in a terrible position once again. Maybe not kicking so much ass this week. Quote, "Every Saturday until June of next year, he's responsible for all league activity," Lambert said. The Pac-12 declined comment. So that is the story from Pete Thamel. There was also mention at one point in this, just following some of the updates on Twitter, that George Kliavkoff is currently just in Montana, owns property there and is just hanging out. I I guess if I took an L the way that he did in this whole realignment thing, I would probably just retreat to my nice place out in the middle of nowhere. That is where George Kliavkoff is at the moment. We'll throw in some other details here from John Willer's story. This is a statement from President Murphy at Oregon State. Quote, "I am pleased with today's decision. As the two remaining Pac-12 members, Oregon State and Washington State, we must be able to chart a path forward for the Pac-12, not the members that have chosen to leave it." Washington State President Kirk Schultz called the decision a step in the right direction. That's probably the most fair way to characterize this. If you're kind of asking yourself, okay, like what exactly does this mean? It's a step in the right direction for Oregon State and Wazzu. We're still stuck here dealing with the mess and the aftermath of everybody leaving the league. This is a step in the right direction for them being allowed to actually take some of that money that is coming in from the NCAA tournament, college football playoff, etc., the war chest that you hear people speak of, as opposed to allowing the conference to be dissolved by voting members who, frankly, they shouldn't trust. You know, I get that the opposite side is trying to argue here, hey, we need this meeting to determine league business and keep people on board and keep it. You can't be trusted. You can't be trusted. You went behind everybody's back. And if you are to believe the John Wilners of the world, Oregon and Washington were ready to sign that grant of rights that fateful Friday morning, and then at the last minute completely change their course. How could you trust any of them? You can't if you're Oregon State and Washington State. There is too much money on the line there for athletic departments that are going to be hurting financially here. One last little bit here from Wilner's article. Washington State and Oregon State, which initiated the legal action against the conference last week, fear the meeting could result in the 10 outgoing members voting as a block on a plan that would harm the two schools left behind in the realignment game. According to Eric McMichael, the attorney for plaintiffs from the firm Keeker, Van Nester, and Peters, one of the discussion items for the board meeting involved using Pac-12 funds to help offset transition costs for the departing schools. The defense attorney, Mark Lambert, called that a mischaracterization. So again, an item reportedly or allegedly on the board meeting agenda was going to be using Pac-12 funds to help offset transition costs for the departing schools. This is why Oregon State and Washington State were worried. If that's even a remote possibility based on what's on that outline, you got to stop that, man. You can't let those schools pay for their way out with that war chest that would be left for Oregon State and Washington State. I am firmly in support of Oregon State and Wazzu here. Everybody else needs to just screw off and understand why this is the case, why this is happening. Happy to see this for Oregon State and Wazzu. Hope it continues to go in their favor because they deserve everything that they can get right now with the position that they have been left in. So happy to see this. We'll keep you updated on the story. Next live show is coming up on Wednesday, so make sure that you are tuned in for that. If you haven't subscribed, subscribe and then click that bell. That'll let you know when I'm going live and when I've dropped content. The live shows are a ton of fun if you have not been there. Please like the video. Please leave a comment underneath. All that stuff helps, whether you agree, disagree, love me, or hate me. All of that is great. Helps with the YouTube algorithm, and you can support the channel on Venmo at John-Kurtz-4. Take care, and I will talk to you all soon.